planning and the key legal and tax issues that arise in the context of devising a succession plan. I'm also going to give you an overview of the types of trusts that are commonly used in this area, and to give you an outline of the main types of trusts that are used. And then at the end I'm going to touch on the tax reliefs that arise both with regard to CAT and CGT. And then finally I'll just give you a few tips that you might find useful when dealing with clients and devising an estate plan. So when we talk about succession planning, what we effectively mean is the orderly and tax efficient transfer of wealth between individuals. Typically that takes place from one generation to the next, but that isn't always the case. And I guess the core elements to consider, or the main factors to consider when devising a succession or an estate plan, would firstly be legal effectiveness, so that the plan that you're devising actually achieves what it is that the client wants to achieve. Also tax efficiency, so whether the plan is as tax efficient as possible. I'm sure most people know that your clients don't like to pay unnecessary tax unless they have to do so. And also tax efficiency is quite an important factor when considering the timing of estate planning. So whether somebody wants to transfer assets during their lifetime or on death, because there are different taxes that might arise depending on whether a transfer takes place during lifetime or on death. Finally, the other main consideration is practicality. So it's very important that whatever plan you devise is practical from your client's point of view, because it's all well and good to come up with a very elaborate estate plan that involves numerous steps and stages. But if your client doesn't have the appetite for that, then you're wasting your time really. You need to have something that is suitable to the client's circumstances and is workable for them. Now trusts are equally relevant both to use in a lifetime estate planning context and also under wills. So I'm going to talk to you in detail about trusts and how they can be used in this area. So for many individuals, estate planning can be a very straightforward process. For example, if you have clients who are perhaps a married couple and they have all adult children who are all sensible, mature adults, there aren't any issues with any of the children, then that can be a very straightforward estate plan. So the clients might decide that they want to leave everything to each other on the first instance, and of course CAT, spousal exemption, would apply so that there would be no tax on the first death. And then they might divide everything equally between their children on the second death. Now in other cases, and I think in modern days, there are frequently numerous complexities that can arise. And examples of complexities would be where individuals are divorced and perhaps on second marriages. Individuals might have children from non-marital relationships. Equally, there could be some issues or concerns with the children themselves, so that the children may be in marital difficulties, or they may have debt issues and it might not be appropriate for them to receive assets in their own name. Equally, clients might have children with special needs, and particular care needs to be put into planning an estate plan for those individuals to ensure that the children with special needs are looked after. Also, just the nature of the assets could give rise to complexities. You might have very complex asset structures involving numerous entities, both offshore and onshore, and that just gives rise to added issues and the need to get advice, possibly in foreign jurisdictions. And I would suggest that, particularly where there's real property abroad, that you would seek local legal and tax advice, because if you are devising an estate plan in Ireland, you need to make sure that that estate plan ties in with the laws of the foreign jurisdiction. And while the introduction of the Brussels IV EU succession regulation has simplified matters in some respect, in that individuals can now choose for the law of the state in which they're habitually resident to apply to succession of their foreign properties in states that have signed up to this regulation. It still doesn't deal with any tax issues arising. So it would just mean that if you had a client who has a property in France or Spain, a holiday home, they can choose for the law, Irish succession law, to apply to succession of that foreign property, so they can avoid forced heirships or rules in that jurisdiction, but there might still be tax consequences of the inheritance in that jurisdiction that need to be looked into. The first step in making an estate plan is to make a will. In Ireland, there's a presumption of testamentary freedom, which means that testators are free to devise their estate as they see fit. So potentially, testators could leave everything to a charity, and they're perfectly entitled to do so. Now this is in stark contrast to, as I just mentioned, the forced heirship rules that are in place in a number of civil law jurisdictions around the world. The only qualification in Ireland to the presumption of testamentary freedom is in circumstances where an individual is married, in that the surviving spouse is entitled to a legal right share in their deceased spouse's estate. So the legal right share, if there are no children, is 1/2 of the estate, and if there are children, it's 1/3 of the estate. Children in Ireland don't have any automatic right to a share in their parents' estate, but as I'm sure you all know, they can make a claim under Section 117 of the Succession Act, seeking a greater provision out of their parents' estate in circumstances where they feel that their parent failed in their moral duty to properly provide for them in accordance with their means. Section 7117 cases are quite common in Ireland, and the court, in considering a claim under Section 117, will look at all of the circumstances of the case. So they will look at what provision the testator made for that child, both during their lifetime and under the will. They'll also look at what provision has been made for any other children. They'll look at the means of the parent and of the child. And after considering everything, if the court decides that greater provision should have been made for that child, the court can reach in and alter the terms of the deceased will and make greater provision for the child. Unfortunately, Section 117 cases can really be catastrophic for an estate because they give rise to legal fees in potentially hundreds of thousands of euro. So either that could completely or significantly erode an estate. And also there's the family element of it, in that family relationships, if already strained, often are completely broken down at the end of a Section 117 case. So my advice would be, if an individual comes to you and they say that they either want to completely disinherit a child or want to provide for their children unequally, potentially quite disproportionately, that I would really suggest that you strenuously outline the possible consequences of a child bringing a Section 117 claim against their estate. Because I found that, obviously the client is still entitled to do so, to provide for their children unequally, and there might be very valid reasons for doing that. But I have found that many clients don't understand what can actually happen if a child brings a Section 117 case and the effect that that can have on their estate. And when they sit down and consider it, you'll find that frequently parents, the last thing that they want is for their estate to enter litigation and for there to be fighting between their children. So they might want to consider perhaps making a different plan under their will, which might be less likely to give rise to litigation. Now, equally, some clients will always come back and say, no, I steadfastly do not want to give my son or daughter anything, and that's fine. Once you have set out the advice in detail, and once you have a very detailed attendance note of it, there's nothing you can do. You follow your client's instructions. Lifetime estate planning is also something that individuals might want to consider, particularly where they have surplus wealth that they won't require during their lifetime. A very important factor if you're going to consider lifetime estate planning is what assets you're considering transferring, because I would think that there are some assets that it might not be appropriate to transfer at any stage during your lifetime. Particularly, I would usually not recommend that clients transfer a family home, purely for protection purposes, so that individuals will always have a roof over their head, because sometimes individuals do come to you and they say, well, I want to transfer the family home to my children now, and they're going to let me live there and it'll all be fine. And you say, well, that's all well and good, but what happens, if 5 years down the line, 10 years down the line, and there might be in-laws involved, there could be a falling out, and then they decide to turf you out, and if you don't have any rights, if you haven't retained a life interest in the home, then the property is in the child's name, and you could then be out in the street. So unless there are very extenuating circumstances, I don't think I would recommend transferring a family home during a lifetime. But there are other assets that it could be quite appropriate to transfer during lifetime, such as cash, because if there's a surplus of cash, a transfer to a child won't give rise to any CGT, which a transfer of other assets during lifetime normally would do. And also stamp duty, the beneficiary wouldn't have any stamp duty liability on the receipt of cash. as I kind of touched on there, it's very important to note that both capital gains tax for the transferor and stamp duty for the beneficiary will usually arise in the context of a lifetime transfer, but they don't arise in an inheritance context. So if a client is coming to you and they simply say, oh well look, I'll just get rid of it now because I don't really need it and it would be better for my child to have it now, when they then understand that, okay, that's fine, but you're going to have a gain on that of 33% since whenever you purchased it, and also there'll be stamp duty for the beneficiary. Usually individuals haven't considered these things, and when they do, and when they realise that those taxes wouldn't arise on death if the assets were to pass to the children under their will, then usually they're quite willing to wait and leave the assets pass under their will. Now, capital acquisitions tax will arise both in the context of lifetime planning and in an inheritance tax context. So the beneficiary will have to pay capital acquisitions tax at a rate of 33% on whatever they receive, which is above their tax-free threshold amount. The current tax-free threshold amounts for children is €310,000, and the government indicated a couple of years ago that they were going to increase this up to €500,000, and there were increases both in Finance Act 2015 and 2016, but there wasn't any increase in Finance Act 2017, which I think was a surprise to most practitioners, that we thought there would be another incremental increase. In the context of lifetime estate planning, often when this arises is when individuals are considering transferring a family business and or agricultural land to their children. And again, these types of assets might be appropriate to transfer during lifetime because there are significant reliefs associated with the transfer of either a family business or agricultural land, which could make the transfers tax efficient. So I'm going to touch on those reliefs later. Now, to give a bit of detail about trusts, as I said, trusts are commonly used in an estate planning context because they're very flexible vehicles that can provide either time or flexibility for numerous purposes. They're also protective mechanisms in that trusts can protect the capital of the trust fund, and they can also protect vulnerable individuals. For example, if you have an individual who is incapacitated or has special needs, it may not be appropriate for that individual to receive a large capital sum because they would not have the capacity to look after, to manage that capital sum themselves. So a trust gets around that in that individuals can appoint trustees to manage the trust fund on behalf of that incapacitated individual, and so they're ensuring that that individual is protected by the trustees. The most common types of trusts that we use in an estate planning context are bare trusts, fixed trusts, and discretionary trusts. So bare trusts are the most simple form of trust. It's simply where you have a trustee holding the legal title to the property, but the beneficiary is always absolutely entitled to the trust fund. So the trustee has no functions to perform other than to simply hold the legal title. Where you'll see bare trusts used quite frequently is in the case of minors, because minors don't have legal capacity to hold assets in their own name. And also bare trusts are frequently used for privacy purposes, say in the context of a share purchase, where the purchaser doesn't want their name to appear on a share register. So the shares could be bought in the name of a nominee trustee whose name would appear on the share register, and then a short declaration of trust will be executed by the trustee to say that he holds those shares on behalf of the beneficiary absolutely. So bare trusts are looked through for tax purposes, which is an important point because it means that the beneficiary is assessed on any income or gains within the trust, not the trustees. So the beneficiaries would have to return any income or gains within the trust in their tax returns. Now, just to mention that in the case of trusts for minors, the beneficiaries are assessed on the income, but only provided that the trust is irrevocable and provided that the income is accumulated. If both of those conditions aren't met, then the settlor is assessed to the income of the trust, and the settlor will have to pay income tax on any income. Fixed trusts then are another type of trust that is commonly used, and fixed trusts trusts are where you have a beneficiary who is entitled to either a specific share of the trust fund or has a specific right, a specific fixed right in the trust fund. So for example, life interest trusts are one type of a fixed trust where the beneficiary, the life tenant, has an interest in the trust fund or is entitled to receive the income of the trust fund for usually their lifetime, but it could also be the lifetime of another person. And usually the interest is limited in that it's only in relation to the income, but often trustees are given a power to advance capital to a life tenant so that capital appointments could also be made out of the trust fund to the life tenant. And actually I was involved in a case recently where there was a life tenant and the trustees made the decision to appoint all of the capital to her. So my client, who was the remainder man, ended up getting nothing in that case. So, while typically their interests are limited, it can be the case that if there is a power to appoint capital, they can, get more than just a life interest in the trust. Life interest trusts can be appropriate, say, if you have an individual who is on their second marriage, but where there are children of the first marriage. They might want to protect the capital for the benefit of their children, but they might want to ensure that their spouse is provided for during their lifetime. So what they often do is that you could create a life interest trust for the spouse, so that the spouse would be entitled to the income from the trust fund during their lifetime. And also, if there was a property or a family home, they would be entitled to live there during their lifetime, which is usually a big concern of clients. But then on the death of the spouse, the trust fund, the remaining trust fund, is divided equally between all of the children. Another type of fixed trust is where you have beneficiaries who are, say, equally entitled to the trust fund or entitled to a 20% share, or whatever it may be, so where they have a fixed share in the trust fund itself. And this you'll frequently come across in the context of parents providing for their children, where they want to delay the capital vesting in their children until they reach an age such as, it might be 25, it might be 27, it could be 30. But often clients feel that they don't want large amounts of capital to vest in their children at 18, so they want to delay that, and to do that they could use a fixed trust. Now, one issue that I would see with that is because a fixed trust is obviously fixed, it's completely inflexible. So if a client establishes a fixed trust in his will for his minor children at a stage when they're quite young, say under 10 maybe, and he says that the trust fund is to be divided equally between them when they reach the age of 25, if the client then dies and the trust is held on trust for the benefit of the children until they reach the age of 25, if something happens to any of those children in that intervening period, there's nothing that can be done to alter the terms of the trust. So, for example, God forbid there was an accident or a car crash and one of the children became incapacitated and had significantly greater needs than the other children, he or she can't receive a greater share in the trust fund, which if perhaps the parent was alive, they might have done themselves. Similarly, if a child develops, say, a gambling addiction or an alcohol addiction, and if it might not be appropriate for that child to receive a large amount of capital, again, that child would have a fixed interest and there's nothing that can be done to change that. So because of the inflexibility associated with fixed trusts, and also because there are technical tax issues that can arise on the taxation side of things, fixed trusts aren't usually the structure that I would recommend in an estate planning context. What I think would be the best structure to use usually would be a discretionary trust, because this is the most flexible type of structure in that it involves trustees being given absolute discretion as to how the trust fund is administered. So trustees will decide who receives what from the trust fund and when. And while that sometimes individuals aren't comfortable giving that level of discretion to trustees, it is qualified by a letter of wishes which would accompany the will or the trust deed, in which the settlor of the trust would set out their wishes with regard to the administration of the trust. And individuals can put as much information as they wish into the letter of wishes, and personally I feel that the more information that's there, the better. And I think that trustees might also welcome it because it assists them in knowing how to carry out the settlor's wishes with regard to the administration of the trust. Very importantly for discretionary trusts, They delay they delay a CAT liability because the beneficiaries have no fixed interest in the trust fund. All they have is a right to be considered as a beneficiary, and they have to be one of a class of beneficiaries. So you can't just have one beneficiary of a discretionary trust, because if you did, there would be no discretion. So because the beneficiaries have no fixed interest, a liability to CAT can't arise until such time as they receive something out of the trust fund. So once they receive appointments from the trust fund, that's when your liability to CAT will arise. This slide shows some of the frequent uses of discretionary trusts. So firstly, parents who have young children and have significant assets, as I mentioned, they might not want their children to receive a very large inheritance at the age of 18, and so for that reason they could pass their estate on their death to a discretionary trust, which would provide flexibility and allow the trustees to hold on to the trust fund until such time as the children are more mature and sensible adults, and until they would manage a large inheritance wisely. Another very common use is in cases where children, or where individuals have children who lack capacity or who are unable to manage their own affairs. And this is a very important area because, as I mentioned earlier, such individuals, or individuals who lack capacity, they can't look after their own affairs. So if they received an inheritance of €500,000, they wouldn't be able to deal with that. And parents of those children are often very concerned as to how they're going to be provided for after they pass away. So a discretionary trust is quite a good structure in that the parents can choose trustees to act and to look after the trust fund and manage it on behalf of the children, and to make appointments out for their benefit, or depending on the level of incapacity, they might be able to receive small appointments so that they have living, pocket money and are able to live possibly independently, but just they might not have the capacity to deal with a large inheritance. There is a tax that I'm going to mention in a few minutes associated with discretionary trusts called Discretionary Trust Tax, but I just want to flag at this point that trusts which are established for either incapacitated or improvident individuals can qualify for an exemption from discretionary trust tax under Section 17 of the CAT Act, so that no discretionary trust tax would arise. And just to mention that Revenue updated their CAT manual in October last year and outlined what comes within the meaning of improvidence, which would be needed to satisfy the exemption. So they said that, say for example, somebody who suffers from a gambling addiction or an alcohol addiction, that those types of circumstances could qualify for the exemption. And also that persons who are spendthrifts, interestingly, could qualify. So it's not, I think we're probably all guilty of going out and spending a bit too much money from time to time, but you need to show it's something beyond that. It's somebody who really has a history of being unable to manage money wisely. And Revenue have said that it has to be proven to their satisfaction that the conditions of the relief are met. So it's very important that you would have, again, a detailed letter of wishes to accompany the will or the trust deed, which would set out examples of situations which illustrate how the client is either incapacitated or improvident. So in the case of a spendthrift, you would need to show, as I said, numerous examples and quite a detailed history of their inability to manage money wisely. Just to mention briefly that in the case of a trust established for incapacitated persons, there's also an exemption from CAT under Section 84 of the CAT Act in respect of appointments made from the trust fund for qualifying medical expenses of that incapacitated individual. And again, Revenue just updated the CAT manual on this last week to say that it's the donor's intention that will determine whether the relief whether the relief can be availed of. So you need to set out, either in the will or in the letter of wishes, that the donor is setting up this trust for the purpose of providing for the incapacitated individual and for discharging their medical expenses. And that's very important because if that isn't there, Revenue have said that the exemption won't apply. Another use of discretionary trusts is for individuals who have children who are in financial difficulties or who have debt issues. which we frequently see since the recession, where it's not appropriate for those individuals to receive assets in their own name. So what the parent could do is leave that child's portion of their estate to a discretionary trust for the benefit of that child and also that child's children, potentially, because that would allow the trustees to generation skip and to provide for the grandchildren if it was never appropriate for assets to pass to that child. Equally, the discretionary trust would give flexibility so that if that child resolved their debt issues and could receive assets in their own name, then the trustees could appoint assets out to them. Parents of children who are experiencing marital difficulties may also want to include a discretionary trust structure in their will for the benefit of that child, but this isn't an absolute protection. So just to mention that the courts and family law proceedings can always alter the terms of the trust or go in and direct that appointments be made. But it is an added layer of protection, and sometimes individuals feel more comfortable knowing that there is that added layer there. The final example on this page is a very frequent use of a discretionary trust, and it's just simply to provide flexibility for timing. So firstly, timing for inheritance tax payments, because if assets are left to beneficiaries directly, then they're looking at a CAT bill in the next 12 to 18 months, so that could cause issues itself, just having to raise liquidity to pay a CAT bill, and it might lead to a fire sale of assets, which wouldn't be appropriate. Because the discretionary trust delays the CAT liability until such time as assets come out of the trust, clients often want to use that, particularly where there's significant wealth involved and where it could be a very large CAT bill. And then in tandem with that, the discretionary trust, because it provides timing, can also be used by the beneficiaries to allow them to arrange their affairs to see if they can qualify for many of the tax reliefs. Because the discretionary trust, as I said, it delays the inheritance, and typically the tax reliefs are assessed on the date of inheritance, so they can qualify, if there's, say if it's business property relief and there needs to be restructuring done in the company or something like that, it gives you a bit of time to arrange your affairs and get your ducks in a row to see that, to make sure that you can qualify for the tax reliefs. I'm just going to quickly run through some of the examples of discretionary trusts. So in this first example, we have Paul and Kate who have 3 minor children, and one of those children has a learning difficulty. So what Paul and Kate might consider doing is establishing 2 separate discretionary trusts in their will. So one discretionary trust which would be specifically for the child with special needs, and then that child should be able to avail of the exemption from discretionary trust tax and potentially also the exemption from CAT under Section 84. The second trust established under the will should have all of the children as beneficiaries, so that if there is a need for a top-up of funds to the first trust, which is the trust for the child who has special needs, then the trustees will be able to do that and transfer funds across. And obviously this is presuming that clients have sufficient assets to look after all of their children, which isn't always the case, unfortunately. But in this example, Ringo is a widower with 4 adult children, and 2 of his sons suffer from alcoholism. He has an estate worth €6 million, and Ringo is considering disinheriting his 2 sons because he believes that they would be better off not receiving anything from his estate. So this is a classic case where alarm bells should be ringing, and you should be immediately saying Section 117, outlining the costs that could result from a claim, and suggesting to the client that they might wish to consider perhaps providing for their sons in some respect. And what I might consider, or what I might suggest in that case, would be that Ringo should consider establishing 2 separate discretionary trusts for his sons, so that the trustees could provide for them during their lifetime and make small appointments out to them that they could manage, but that they wouldn't have a huge inheritance of €1.5 million that could possibly end up being completely detrimental to them. Ozzy has a family business, and his 4 sons work with him in that business, and he wants to leave his shares equally between his children. But one of his children is in financial difficulty and has debt issues. So in that case, what Ozzy could do in respect of the child with debt issues is leave that child's portion of the shares to a discretionary trust for his benefit. And then that would allow the trustees to assess the situation, and if the debt issues are resolved, they could transfer the shares to the child. If not, they could perhaps generation skip and transfer the shares to the grandchildren. This slide just outlines how the rate of CAT and the tax-free thresholds have changed in the last 10 years.
Sorry, your slides.
Oh. Sorry. Actually, it's not my word today.